Hey, so in this video, we're going to talk about when it just might make sense for a married person who lives in a community property state to convert some or all of their separate property to community property. All right, so I live in a community property state. I work in a community property state. In fact, let me go over what those community property states are in our country. So those community property states are Arizona, California, Idaho, my state, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin. And it is common for married people who live in one of our community property states, it is common for them to own separate property. And then sometimes the family can benefit from that spouse converting their separate property to community property. So let me step back for a minute. First, let's go over what is separate property. And at least this is the definition in my state of Louisiana. So essentially, separate property comes from three sources. A married person will have separate property if they acquired property through a gift. Second reason, if they acquired property through an inheritance. And then third reason is if they acquired assets or property prior to the marriage and brought those assets into the marriage. So gift, inheritance, and property brought into the marriage is community property. And I say property, I don't mean real estate when I mean property. Separate property can be anything. It can be cash, real estate, stock, business interests. So let me give an example of a scenario where it may make sense for a married person to convert some or all of their separate property to the community. So let's say Martha has $1 million of separate property. Doesn't really matter what it is. It could be stock, it could be real estate, it could be an interest in a business. And that asset that is Martha's separate property, she's married to Donald, and that asset was acquired many years ago. So long ago that the value of that asset when it was acquired, maybe 20 years ago, maybe 30 years ago, maybe 40 years ago, the value of that asset when it was acquired was $100,000. So the value when it was acquired establishes the capital gains tax basis, but now it's worth $1 million. So there's a lot of untaxed capital gain or untaxed appreciation in that asset acquired for $100,000. Now it's worth $1 million. Okay, so I think most people know that if Martha sells that asset while she's alive, there'll be $900,000 of capital gain, and there'll be whatever 25% or so state and federal capital gains tax, whatever it might be, that will be due on that capital gain. But we're not talking about Martha selling it right now, but she might need to sell it in the future. So here's the deal. If she converts that asset to community property, she does what she needs to do. We'll talk in a minute about what the form is to make separate property community, but she does it, and she makes that asset community property. Now it's $1 million and it's community property between Martha and Donald. And let's say the next big event that happens is Donald passes away. So Donald dies first. Most men think they die first, perhaps because they do. So because Donald and Martha had community property, when Donald died, under a special step up in basis rule that we have for community property states, all of the community property, not just Donald's half, but Donald's half and Martha's half, all of the community property when one spouse dies or when Donald dies gets a step up in basis. So all of that $900,000 of untaxed appreciation, poof, it goes away. It'll never be taxed because when Donald died, all of the community property enjoyed that step up in basis. So that would have been a tremendous benefit to Martha, particularly if Martha needs, after Donald dies, to sell some of that in order to live off of or do whatever she wants or needs to do. Then she'll really benefit from that step up in basis. Where if Martha had not converted that separate property that she owned to community property, and then Donald died, Martha's separate property would not have enjoyed, or Martha would not have benefited from any step up in basis on Martha's separate property when Donald died first. But since she had made it community property, and all of the community property gets a step up in basis when the first spouse dies, not just the deceased spouse's half, but all of it gets a step up in basis, Martha really could have benefited from converting her separate property to community property, while they both were alive. Okay, and there are no tax consequences to making it community property. It's a gift to the spouse, and yes, normally we have this $15,000 limit on gifts that before tax consequences start to kick in, but that provision doesn't apply on gifts to spouse. You can make unlimited gifts to your spouse without any tax consequences. All right, so let's talk about that. Go back and talk about that provision in our Internal Revenue Code that gives just a significant benefit to couples who live in a community property state, because when one spouse dies, all the community property gets a step up in basis. And the provision I'm relying on is this section 1014B6 of our Internal Revenue Code, which says that that property acquired or passing from the decedent, and that's the assets that get a step up in basis. It's the property that passes from the decedent or from the person who died gets a step up in basis. And when we look at our provisions of our tax code, it says that property acquired or passing from the decedent includes property which represents the surviving spouse's 1/2 share of the community property held by the decedent and the surviving spouse under the community property laws of any state. So you might think, well, why? That's an unfair advantage to people who live in a community property state. You may be wondering, why in the world would the Internal Revenue Code give such an advantage to married people who live in a community property state? Well, I think the reason is because this provision was enacted back in the 1940s. And back in the 1940s, in a non-community property state, back in the 40s, it was the husband who would acquire all of the assets, and he would acquire all of it in his name. And then in that non-community property state, it was typical for the husband to die first. And so really, in a non-community property state, in the good old days, husband acquired it all in his name, husband died first. So in theory, all of it got a step up in basis when that husband died first in that non-community property state. So I guess Congress at the time said, well, that's not fair to the community property states, because if the husband is acquiring everything during the marriage and it's community property and he dies first and only his half of the property gets a step up in basis, well, that's an unfair advantage to the non-community property state. So maybe the roles have switched today, but now here we are in the 2020s. So anyway, that's the rule, and that's what it is. When one spouse dies, all of the community property gets a step up in basis. So next thing I want to cover is how does someone convert or make separate property community property? Well, I'd say it depends on what that particular asset is. And I'll start with a presumption rule that we have in our state of Louisiana that says that things in the possession of a spouse during this community property regime are presumed to be community, but either spouse may prove that they are separate property. So you start with the presumption that an asset in a spouse's name is community property. But you want to have more proof than that when you want to really formally convert some separate property to community property. So if you're converting real estate from separate property to community property, you're going to do some formal real estate transaction, have it recorded in the real estate records to show that you've made this gift to your spouse or you've converted it to community property. If you own stock or perhaps a business interest like an LLC or S corporation stock, you're going to want to document that also with some type of act of donation to the community so that even though that stock may stay in your name, even though that business interest may stay in your name, you can show that formally you did what you needed to do to convert that separate asset of yours to the community. So now, why wouldn't, in our example, Martha with her $1 million piece of separate property, why wouldn't she want to convert it to community property? Well, there's a couple of reasons. Maybe the obvious one is if Martha and Donald divorce after she has converted her separate property to the community, she's just lost half of that property because Donald owned half of it once she converted it to the community. So we typically don't see a lot of these conversion of separate property to community in young people recently married for that reason. But for those folks who have been married for, as they say, forever, maybe they were married 30 years, 40 years, maybe they've been married 50 years, and usually one set of children, one marriage, one set of children, and so the family goals are clear and consistent throughout the whole family. That makes it less likely that there's going to be a divorce and one of those adverse consequences of converting separate property to community property. And then, the other reason someone might not want to convert their separate property to community property is that person who converted it, once they converted it to community property, they no longer have the right to control the disposition at their death of all of that property. They only own half of it, so they can only control the disposition of half of it. So they wouldn't perhaps convert it to community property if there was a concern that their spouse may dispose of it to someone else, for example. Okay, and the other issue that has to do with converting separate property to community property is the estate tax. Not as much of an issue anymore. Used to be, there could be some pretty significant estate tax penalties if one spouse had a very large estate and another spouse had a very small estate. The penalty being if the spouse with the small estate died first. Now the surviving spouse had a large estate subject to estate tax when the surviving spouse died, and the estate that had the smaller estate, the spouse who had the smaller estate, they didn't get to utilize all of their estate tax exemption. However, now with elections like the portability election, spouse with small estate dies first, executor can make an election so that the surviving spouse's estate not only gets their own estate tax exemption, but gets the estate tax exemption, unused part of the estate tax exemption of the first spouse to die, because of the portability election and because of the marital deduction, where if rich spouse dies first, he can leave things to his spouse in a way so that no tax is paid at the death of the first spouse, and both estate tax exclusion amounts are used. I'll have to beef up my videos on both portability and the marital deduction so that you can really understand that, and some of that is a little bit difficult to understand on the first time you see it. So that'll be coming in our video list. So anyway, I just wanted to identify, and before I wrap up here, I do want to emphasize how important it is that you subscribe to the channel and then hit the notification bell. That way you don't miss anything as I publish various estate planning educational videos. Also, just trying to grow my subscriber list. I think at the time I'm making this, it's about 4,100. Trying to get it up there to maybe 10,000 or so would be phenomenal. That'll motivate me to keep making these educational videos. So, and if you can smash the thumbs up button if you thought this provided you with some assistance, that'd be great. And if you can share this, maybe you know people who live in a community property state but own some separate property, and they're kind of getting up there where they maybe want to consider converting that to community property. They'll thank you for sharing this information. So, enough said. As I wrap up here, just wanted to summarize some of those capital gains tax potential benefits for a spouse with separate property to convert it to the community. Tune in every morning, 10 a.m. Central Time. New educational videos. Y'all have a great day. Y'all take care. See you next time.